Hi, everyone. So today we are just going to have a bit of a chat about the current state of US immigration because it has been a hell of a month, right? We are halfway through the month, um, and it has already been so much that has happened. So remember, if you're joining me and you have questions, you can put it in the comments. And I just want to take the time to just talk about what has happened, what may happen in the future, and how things are going to be affecting um, green card applications. A lot of what I do in my practice is marriage based and family based green card applications, citizenship applications. So that's going to be the focus of this talk. I always like to focus on the things that I am um, basically very well knowledgeable on, and make sure that I am giving you information as quickly as I have it. All right. So if you have questions, be sure to put it in the comments. If this is your first time here or you don't know who I am Lillian Chukura. I'm a US based immigration lawyer, and I help my clients get green cards and citizenships for themselves and their families using the US immigration law system. If you're joining me, feel free to say hi. Let me know where you're joining me from. I am always amazed at um, just where you all are joining me from and the people that join. So, and also ask me questions in the comments. That's really the point of today. Like when I do these live sessions, the point is for you to ask me questions. I do have videos that I post on Tuesdays that are more teaching, right? I'm telling you, giving you more information about different case types and things like that. But on Fridays, it's kind of just a more relaxed time for us to chat about US immigration and for you to ask me questions. Hi, Mubarak. Thank you for joining me. Mhm. So, hi there. Remember, ask me questions. Right. So let's jump right in once that goes. Let's jump right in. So when it comes to US immigration, as you all know, since January 20th, things have just been, um, what's the word I'm looking for? Chaotic. Okay, things have been chaotic. And a lot of people, there's a lot of misinformation out there. There's a lot of things that are changing. And I want to make sure that you are aware that those things are changing because it can affect your green card application. One of the biggest things that I want to talk about with you all is the fact that applications are going to get a higher level of scrutiny. Okay. This is not to say that USCIS was not, scrutinizing cases before. They weren't just approving cases before. We know that for a fact, right? They were still doing their fraud investigations and all those things. But now more resources are being taken from officers that are reviewing applications and putting more towards officers that are doing the fraud investigations. What does that mean for applications? We suspect that those applications are going to take longer, right? Green card applications are going to take longer. Now, when it comes to fraud investigations are one of the things that makes green card applications take longer. It's not whether your marriage is real or not. It's really if there's a suspicion that there could be something amiss, like there could be, right, a suspicion that your marriage is not real and it goes into that fraud investigation pipeline, it is going to take way longer for your application to be approved than if it was on the normal timeline. Okay. So that's why I say we're most likely going to see applications take much, much longer to be approved. All right. But one thing you need to know is that applications are still being approved. Okay. So applications are still being approved. Is it, are you going to need more to make sure that you are giving yourself the best chance? Yes. Okay. Yes, you're going to need more evidence of your relationship. You're going to need to really make sure that every single thing that you're given to USCIS when it comes to your application is the right stuff. Okay. It actually makes a difference. So, for example, when you're filing a marriage based case, sending in just your marriage certificate as proof of your marriage is not enough. It wasn't enough before this administration, and it's definitely not enough within this administration. Okay. So sometimes people will file a I-130 for their spouse, and all they send in is the marriage certificate, as if the marriage certificate on its own proves that the marriage is real. There's two parts to a marriage-based green card application, right? The first part is you are legally married. The second part is the marriage real, right? The officer has to find both, that you are legally married and that the marriage was entered into in good faith, meaning you two are actually trying to build a life together. You two are actually planning on staying married, and you're living together. You're telling the world that this is your spouse. That's what USCIS is looking for when they're looking at those cases. And if you are not showing that with your application, you are doing it wrong. Okay. If you are not presenting as much documentation as possible of your relationship when you file your I-130, I'm sorry, but you're doing it wrong. You were doing it wrong before this administration, and now you are definitely doing it wrong, because they are looking for every single opportunity, every single thing that they can use to deny your case. So you want to make sure that everything you file, you are including as much evidence as possible. Okay. And then after they announced that they're going to basically scrutinize every single case even more than they already are, now they're also released the NTA memo, which is basically they can now issue a notice to appear when they deny a case. So if you file a green card application and that application is denied, USCIS officers are now encouraged to file a notice to appear and put the person in deportation proceedings. What does this mean for you? Let's go back to the first point. You want to make sure that you are following the instructions and that you are presenting a strong case for your application. Okay, you need to put in as much evidence as possible to make sure that you are showing that your marriage is real, that you entered into it in good faith, and that it is a legal and valid marriage. So every time I say legal and valid marriage, people are like, what does that even mean? It means that you are legally married. So wherever you got married, your marriage is legally recognized. Okay. Now, if you did not wait for your divorce to be final before you married someone else, depending on the state you live in, your new marriage is not legally valid and can never be legally valid until that previous marriage is finalized, right? Until that divorce is finalized, and you may have to remarry your current spouse. Massachusetts is one of few states where you don't have to get married again. As long as that previous divorce is finalized, then your current marriage becomes legal. But in most states, that current marriage never becomes legal if it took place before the previous one legally ended. So you want to make sure that you have your divorce decree and it lines up with when you got married. All right. You can get married a day after your divorce becomes final and legal, right? You can get married a day after, but you cannot get married the day of or the day before. But the day after, you are free to get married. You are legally free to get married. That's what they're really looking at there, okay? And if you are in different countries and you get married through a proxy, meaning you two were not in the same space when you got married, you need to prove to USCIS that you consummated the marriage for it to be a valid marriage. for it to be a valid marriage. So that is really the point here, is that the marriage has to be legal, one, and then you need to make sure that you have evidence that you two are in a relationship. Okay. So what does this look like? Because I've had people ask me about, how long should I wait after I get married to file an I-130? And the truth of the matter is, it depends on your evidence. Okay. It really depends on your evidence. If you had a long dating relationship, a long engagement, you would have, text messages, pictures, maybe you took trips to see each other, things like that, right? You would have those things to present as evidence of your relationship, even though they took place before you got married, right? Even though those things took place before you got married, you want to still, right? You want to still present those, because it tells the officer that, hey, there's a whole dating relationship that happened. I've had clients where we included their text messages, and in there, right, they were discussing, their traditional marriage, what outfits, making sure that, all the bride price and this and like all those things was part of the conversation they were having on a regular basis leading up to the wedding. So those are the type of things that make a difference, because it shows the officer that you two are not just like telling them that you're married, but you're presenting evidence that shows how the relationship developed and how you got to the point that now you're married. So very, very important that if you are filing right after getting married, that you don't just look at things after you got married, right? Living together, if you were living together before you got married, you can present that as proof of your relationship. And then once you're married, if there's additional things that you have, even better, okay? Okay, so Jay is saying a child born to a newlywed couple should be strong evidence of a real marriage. Am I wrong? You are not wrong. One of the best evidence of a marriage is children. For USCIS purposes, one of the best evidence you can have that your marriage is real is having children within that marriage. Because in the US, if you have children with someone, even if you get a divorce, you two are still attached to each other forever. It's a joint responsibility. Someone may be paying child support, there may be custody arrangements. Most people will not willingly put themselves through that just to get a green card. Okay. So having children together is a strong, strong evidence of your relationship. Again, I never start with that, because I'm not going to encourage anyone to have a child just so they can prove that their marriage is strong. All right. If you don't want children, that's fine. You don't have to have children to prove that your marriage is real. But if you do have children, make sure you include their birth certificates to show officers that, hey, we have a child, we have multiple children together. This should be proof enough that our marriage is real. Okay. So you really want to make sure that you're documenting those things. And sometimes, even if the child is born before the marriage takes place, it still shows proof of the relationship between the two of you, and that you have this bond beyond just being a married couple. You're also parents to the same child. Okay. So remember, you can ask me questions in the comments. More than happy to respond to those. So the NTA memo is a big deal, and I hope anyone filing any application with USCIS takes it seriously and knows that every single step you're taking is going to be scrutinized, right? They're going to be looking at every single application. You want to make sure that you're taking steps. Another thing I want to mention is I have in the past mentioned about expediting your work permit application if you need your work permit faster. And, there was a concern, at least on my part, whether those expedite requests will still be approved. Well, We did one last week and it was approved. So expedite requests are still being approved if the, if the case is appropriate for it. So if the case is appropriate, if you meet the requirements for an expedite request, those are still being approved. So don't stop, right? Don't stop sending those out. If you have a legitimate reason and you meet the requirements for an expedite request, send in your expedite request. Worst case scenario, like I always say, they say no, right? They say no, and then you're still back where you started, right? It doesn't like take your case out of processing. It doesn't do any of that. If they don't approve it, then you're just back where you started and you continue. But don't be afraid to send an expedite request. Like I said, we sent one for a work permit based on a marriage-based green card application that's pending. We filed the work permit. So we filed the work permit in January. We filed the whole packet in January. We did the expedite request last week based on what's it called? Based on a job offer. So when it comes to expediting a work permit, one of the things that can help to expedite a work permit is if the person has a legitimate job offer and the only thing they're missing is that work permit to be able to actually take the job and start working. When that is the case, USCIS is more open to approving a work permit expedite. But if you are not able to show that you have a job offer or there's a financial hardship, USCIS will most likely not approve that expedite request for a work permit. Okay, that does not work for a green card application. Let's make that, there's a distinction there. For a green card application, you really need to show that there's an emergency that requires for this green card to be approved as soon as possible. So one of the ways that you can do that is if there is a medical condition and the person does not qualify for health insurance, and if they did get their work, if they did get their green card, they would then qualify for health insurance under their spouse and be able to get treatment that they need. In those situations, yes, getting an expedite may be approved, okay? But it's really important that you are paying attention to your particular situation and not looking at other people's, because every single case is different, all right? So if one person applies for an expedite for a work permit and they don't have a job offer, they don't have any financial hardship, they didn't present any evidence for why the expedite should be approved, and the other person presents evidence of why the work permit should be approved faster with a job offer, with evidence of hardship, the person that presented the evidence is going to win every single time, right? Over the person that presented zero evidence. So it's really important that when you choose to do an expedite request, that you are presenting legitimate reasons and evidence for why your case should be expedited. Because remember, when your case is expedited, you are asking USCIS to put your case above everyone else's, right? To move your case to the front of the line over everyone else that filed before you. And you need to give them a good reason to do that. So that's why it's really important that you think about why you need the expedite, what documentation you need to show to prove that your case deserves an expedite. And sometimes USCIS will still say no, right? Sometimes you ask for an expedite at the embassy and they still say no, but you want to present documentation to prove that. I want to bring my friend from Zambia for a 2-month visit. How long does it take if I live in New York? So here's the thing. Your friend that's coming for a visit needs to qualify for the visa. It doesn't matter where you live. It doesn't matter, anything about you. Your friend needs to qualify for the visa. That's the biggest thing with the B1, B2 visa that people sometimes don't understand. And especially people outside of the US, they assume that if they have a friend or a family member in the US and that family member sends them an invitation to come to the US, that alone is enough. That may be like 5%, okay, if not less, of the consideration. Okay. So if your friend wants to come for a visit, your friend needs to check if they qualify for a B1B2 visa. That's really the key there. And in order to qualify for a B1, B2 visa for a visit to the US, the person that is trying to visit the US needs to show that they have sufficient ties to their home country. Okay, that they have no reason to want to come and stay in the US and overstay their visa. That is really like the biggest part of the B1, B2, and most non immigrant visas is that you have to show that you have a lot going on for you. And I will give you, like, if the person is young, just finished school, no, they're not married, they don't have kids, they may or may not have a job. And if the job is like entry level, that they have zero responsibilities other than showing up for work, the likelihood of them getting a visa is slim. So the younger you are, the less money you have, the less assets you have, the less family connections you have, the less likely you are to get those visas. Okay. If the person, let's say, is the head of a bank, is like the CEO of a bank and is coming to the US for a conference held by the UN or something like that, they are more likely to get a visa to the US. Okay. If the person has strong ties in the form of family, so they're married, they have children, they may have a business that relies on them, they have employees that rely on them, and they can show that they have money, right? So your employment and your finances are so important, because if you can show that you have the funds to support yourself, that you are well off in your country, then you're going to have a higher likelihood. And finally, the length of time you want to stay in the US. Is it reasonable? So if you're saying that you have a wife and kids and you have a business and all of this, like, it looks great, but then they look at how long are you planning on staying in the US, and you say 6 months, red flags. Red flags. Because how can you say you're coming to stay in the US for 6 months when you have wife, children, a business that relies on you, employees that rely on you, right? How is that reasonable time for you to be away from your home country? So when it comes to, so all of that to say, when it comes to the B1, B2, you can send an invitation to someone outside of the US. However, that person needs to meet certain requirements. And I should mention, if that person has family in the US and that family in the US overstayed their visa, the likelihood of that person getting a visa to the US is slim. Okay? It is very slim, unless they really can show a strong tie to their home country. All right. Jay, in your professional opinion, how many undocumented people will self-deport? I Ooh, I don't know, right? I don't know a number, but I will say most people that do not have family in the US or an attorney representing them are more likely to self-deport than people that do. Okay. Um, and sometimes ICE may call it self-deport, but they may encourage the self-deport. Okay. So sometimes when someone is picked up by ICE will ask them, hey, we can just let you go. You can go home. Would you like to do that? And just sign this document and you can go home. But if you don't sign it, we'll hold you forever. And, all the shenanigans, and the person will choose to sign and leave. So it really depends on, what I am seeing is people that do not have family in the US, like children, spouse in the US, and people that are not represented are more likely to self-deport than people that do. Also, they rolled out a new app. So they basically reworked CBP1. So CBP1 was created by the Biden administration to help people make an appointment with CBP, the Customs and Border Patrol, to basically make an appointment, come to the border, get interviewed, see if they have credible fear of returning to their home country, and if they do, be put in immigration court proceedings or be paroled into the US to seek asylum, right? That was CBP1. Now they are basically reworking that app to have a button that says self-deport, and the person can put in their information and say that they are going to self-deport. If you have the CBP1 app and you have no interest in self-deporting, please delete the app. Okay, just delete the app so that you do not make a mistake and press the button. Okay, it's really important. What happens to Haitian TPS holders who are married to US citizens now? Will they get to stay in the US automatically? Unless they have filed for some form of status through their US citizen spouse, they're not able to stay in the US automatically, right? If the TPS is not renewed, right? If the TPS is not renewed, then they would be out of status at that point. However, if they're married to a US citizen and they entered with a visa or parole, they can adjust their status in the US, and that's what we're advising people to do. So if you entered with a visa or parole, to go ahead and apply for adjustment of status if you qualify, if you otherwise qualify for it. So if you don't have anything that makes you inadmissible, like criminal records, okay? And then if the person was not paroled or did not come in with a visa, TPS does allow you to apply for advanced parole. We do have clients that we did that for, where they applied for advanced parole, were able to travel outside of the US, come back on that advanced parole, and now we're applying for their green card. So there are options available when you're married to a US citizen. So if the advanced parole is not an option, if you did not enter with a visa or parole, the next option would be to file the I-130. And then once that's approved, file a provisional waiver. So the 601A waiver based on extreme hardship to your US citizen spouse. And once that is approved, you can go to an interview at an embassy and be able to come back with your visa. We actually just did that for a client recently as well, that was able to go out, go to their interview and come back, and now they're permanent residents. So there are options available when you're married to a US citizen that is not available to other TPS holders that do not have that relationship. Any news on the U visa? No, Samantha, no news yet. So during the campaign for presidency, there was a mention of U visas being limited to active investigations and not cases that have been closed. But we haven't seen any real policy change when it comes to that at the moment. Okay, no policy changes. They are still accepting U visa applications, and they are still giving the bona fide determination letters for those that they believe meet the minimum requirement. Okay, Wanda's Pappy. My friend had a traffic ticket that was paid off before she applied for her approved green card, but she didn't declare it when she applied for a green card. Would that affect her during the 2 year of the I-751? So traffic tickets are not criminal charges, okay? And they are the exception to having to disclose. So unless it was like, I believe right now it's like 500 or more that she had to pay in the traffic ticket, it does not count. Okay. So traffic tickets do not typically count. And if it's not disclosed, it's not going to affect anything unless it was something criminal that happened. But typically, if it's like a speeding ticket, you only disclose like typically you don't only disclose a speeding ticket depending on how much you had to pay. Okay, the higher it is, the more you have to disclose it. But if it's like $100 ticket, you typically don't have to disclose that. So she should be fine, right? As long as she doesn't get any more, right? Just right now, my recommendation to everyone is to just have as little interaction with police, with any law enforcement agency as possible. As little interaction as possible is the recommendation right now. Kyle, hi, I came to the USA last year in April and got married in August last year. My wife is a US citizen. We filed the I-130 in September and still waiting for it to be approved. How long does it normally take? So it's going to depend. An I-130 on its own, without a green card application right now, is taking about a year to a year and a half. If you included a green card application, what I would recommend is that you look at the processing time for the field office closest to where you live, because that's the final place your application is going to be processed. Okay. So if you are filing like I'm in Worcester, Massachusetts, right? If you're filing and you live in Worcester, Massachusetts, you would look at the processing time for the Lawrence field office, right? So you need to know your field office if you are including a green card application. But if it was just an I-130 without I-485, then right now the processing time is like 15 months. So just keep that in mind. But if you did include the I-485, don't base it on the I-130, base it on the I-485, because that's what's going to determine how long it actually takes. I do have a video on my channel on how to check your processing time, but you want to look at the I-485 and look at your specific field office that would be hearing, that will basically be determining the case. And that's how you will find your processing time. In Massachusetts right now, with the Lawrence field office, the whole process is between a year and a half that we're seeing for green card applications. But it does depend on the location. There's certain locations that get a lot of applications, and then there's certain field offices that do not. So for the field offices that get a lot of applications, they have a longer backlog than the ones that don't. Okay. Have you ever seen someone who applied for a U visa and got denied within months of submitting? Typically not. When you apply for a U visa, it's accepted, right? So the first step is it's accepted. You get the receipt notice, you get a biometrics, and then it's just processing. They can choose to give you a bona fide determination, or they can choose not to give you a bona fide determination. Depending on the facts of your case. If, let's say, for example, they're looking at your case to see if it meets the minimum requirements and the crime does not fit within the U visa definition, they can choose to deny it, right? They can choose to deny it if you did not meet the requirements. So is it possible? Yes. But have I seen it happen often? No. But it is possible. Am I safe to travel through the country if I don't have legal status in America? I've heard TSA agents ask for legal status now. So that is something we have heard, and we have, there are some airports that have, sometimes have ICE officers have a presence there, I would not travel, right? My opinion, right? This is not advice to you. If I was in that situation, I would not travel where there is CBP officers, there's potentially ICE officers, because TSA is not the issue, right? TSA is not the issue. The fact that you're going through a port of entry, like, especially Boston to California, those are ports of entry that international flights go through. So there's ICE, right? There's CBP. And where there's CBP, they can detain people, they can ask questions. So it's not, I can't tell you yes or no whether you'll be safe, but it may not be, right? It may not be safe. Even traveling by bus, some bus companies used to let ICE, used to stop at locations and let ICE go through, give them access to the bus, and they will ask people for their documentation. Some of them have said that they're not going to do that anymore. However, we don't know. So even if you buy your tickets anonymously, like Jay says in the comments on YouTube, even if you buy anonymously, if the bus stops and lets an ICE agent into the bus, there's not really much you can do about that, right? Because it's their bus. Which takes fewer years to a 10-year green card? VAWA or U visa? VAWA. So a VAWA application itself takes 3 to 4 years. And then once that is approved, as long as you meet the requirements, you can apply for, you can typically apply for a green card application with your VAWA application, so that once your VAWA is approved, USCIS can go ahead and process the green card application. And that typically takes like a year to a year and a half after that VAWA is approved. A U visa, on the other hand, takes far longer to be approved. A U visa right now may take up to 15 years because of the backlog. So U visas have a limited amount of visas available. So it's an actual visa category that has a limited amount of visas available every single year, and it has been backlogged for 15 years. So until you are actually approved, and that can take 15 years, you are not in line for a green card. Okay, that's just 15 years to get the U visa. And then after you get the U visa, you have to wait another 3 years before you would qualify for a green card and be able to apply for a green card. So it is, so the U visa is definitely longer to get to a 10-year green card versus the VAWA application. But sometimes someone may be a victim of abuse, and it's just that the person that abused them is not, their spouse that abused them is not a US citizen or a permanent resident. So their only option would be a U visa. But if on the other side, the spouse was a US citizen or a permanent resident, then the VAWA will be an option for them. So it really just depends on the person's situation, which option would be available to them. Okay. So the speeding ticket, and she paid $220. Does she have to? Yeah, so typically not. She can choose to, right? She can always choose to disclose it. Is it going to make a difference? Not really, because it's a speeding ticket, and the value is less than $300. So she can choose to disclose it. It doesn't hurt her case if she discloses it. Can homophobic discrimination, family rejection, and age-related job challenges in home country be considered valid factors for extreme hardship in a I-601A, if no known health-related issues? So I don't see why not, right? Because the whole point of the I-601A waiver is hardship on the US citizen spouse. If they were to go to the home country with their non-US citizen spouse, or if they were to stay here without their US citizen spouse. What would that life look like? Would they suffer extreme hardship? So if they are in a homosexual relationship in the US and they're freely living their life in the US, and they would be forced to live in a country that either makes it illegal, because there are some countries that it's illegal, and they can get arrested for just living their life, that can be used, absolutely, um, to show that. Age-related job challenges, yes, we've used that as well. And then if they're choosing to stay in the US while their spouse is outside of the US, you can look at, how would the fact that their spouse has to live in that place where they know their spouse is going to go through discrimination and potentially, in some countries, have their life and safety in jeopardy, how would that affect them? And most of the time, what we see is that people typically will have anxiety, and just like the thoughts, right? That what will happen, and just worry about their spouse, and how does that affect someone's health, right? So it may not seem obvious that it's going to affect the person's health, but it actually does, right? Because I have seen that. Just the worry, the concern alone can trigger so many things: depression, anxiety, all of that. So remember that mental health is also health, right? So it's not just physical ailments, it's also mental health issues. So if the person has anxiety, depression, and if that is going to worsen if their spouse was to be sent outside of the US, that's something to tap into. And typically in these cases where there may not be physical ailments, we look at whether there's any mental health components that we can bring to light. And typically, in order to do that, I can't do it because I am not a trained psychologist. That's why I always tell my clients, I am not trained as a psychologist. I am not a therapist. I have no mental health training to be able to diagnose someone. But what I can offer you is getting a psychological evaluation, because a psychologist would be able to talk to you, figure out, look at your entire history and figure out, would this change affect your health and how it may affect you. Because sometimes people don't know that they are predisposed to depression or that they have anxiety until they actually have an evaluation and they're like, oh, I didn't know that's what that feeling was. So can that, everything you mentioned could relate to health, and you may not be looking at it from that lens. But again, I do this so much that whenever someone mentions that, I'm already thinking about the health implications of things, even if they're not seeing the health implications of it as well. Do you think the president will bring back his Nigeria travel ban? So we will find out pretty soon. So on January 20th, the executive order the gave them 60 days to basically come up with a list of countries that may need to be banned. And that 60 days is coming up pretty quick. So we may have a new list of travel bans next week. We may have it. So it's really important, like, that what I'm telling everyone is, if you are already issued a visa to the US, right? If you have an immigrant visa to the US, please travel into the US as soon as possible. Don't wait till like the last week of your visa being valid to travel. So travel as soon as possible. If you have a non-immigrant visa to the US and you want to come on vacation, do your vacation now, not later, because you may be banned. Okay. If you are on a student visa, you may not want to travel outside of the US until you know what countries could be affected, because we did see that affecting students the last time around, and we had to, immigration lawyers were at airports, making sure students are okay, being able to come back to the US. It was a whole fight. So as of now, recommendation, if you already have your visa, travel on your visa. And if you are already in the US on a student visa specifically, and you do not need to travel, just wait. Okay. We're kind of on a wait and see right now. So just wait. Um, my husband is in Nigeria waiting on an interview and medical appointment. His case is with the MVC. How long is the wait? Ooh, it's long. It is long. I believe right now we're seeing like 1 to 2 years of waiting after being documentarily qualified. So not like you've been at the MVC for 1 year. It's after being documentarily qualified to get an interview. It is taking time. And like Jay was asking, if unfortunately Nigeria ends up on the banned list again, that may affect when that interview will take place, unless there's exceptions for spouses of US citizens. Okay. Oh, thank you, Wonders Happy. Thank you. Yes, please share it and also like. All right. If you are not already subscribed, go ahead and subscribe. I try to go live almost every single week. I do take 1 day off a week, depending on my schedule. I kind of figure out when I'm going to take off. But yes, I do take 1 day off, one Friday off a month. So, but other than that, I am here almost every single Friday. And then I do have videos that I post on Tuesdays. Those are pre recorded, but it gives you so much information that I think it's worth it to just take a look at those as well. Yes. Okay. So Manny saying you are right. Health is not only about physical. If we need to get professional help in that matter, how USCIS will react if the report is from a few months ago, if the report is recent. So it depends. So if the person is already seeing a psychologist and the psychologist that they're seeing on an ongoing basis is the one doing the report, it's fine. Right. If the report is recent, it's fine. You really just want to present as much documentation as possible. Typically, for us, I like having the report within like a couple months of us filing. We have had reports like the week before we file. So remember, the meeting with the psychologist takes place, and then the psychologist then writes the report. So the time that the report is actually like given to us to include in the filing is going to be different from the time that you actually met with the psychologist. Some psychologists are able to like get those to us within a week of the meeting and the evaluation. Others take longer depending on their workload. So it really just depends on how fresh, like if nothing has changed, right? If everything in the report is still accurate and is still true, typically we will take the report as long as it's within like 6 months. Anything beyond that, we may need to get updated, right? So that's just the main thing. But beyond that, as long as it's within like a reasonable amount of time, so I'll give you a quick example. I've had immigration court hearings where we did the psychological evaluation, we filed it with the court, and then the hearing gets moved for a year. I didn't have my client do a new psychological evaluation because nothing has changed. The evaluation was still on point and everything was still the same for the client, and the risk that they faced was still the same. So the judge accepted it and even quoted it in their decision. So it's one of those things that it really is on a case by case basis. So, for example, if the report was done 6 months ago, but since then there's been like additional medical issues, or the person was pregnant, but now they've given birth. There's like whatever changes happen, if it's a major shift that would make a difference in the report, I may have the person reach out to the psychologist and see if they can get an updated report. But the fresher it is, the better, right? The fresher it is, the better. But it really just depends on your particular situation. All right. All right. So I always forget to put this banner on the bottom every single time, but it's fine. Let's talk about it. If you are watching this and you would like to meet with me and talk about your particular situation, on these lives, all I can do is answer your questions in a general manner because I know nothing about you, right? I know some of you join me every single week. Manny, I see you all the time. Mrs. Ella, I see you all the time. Jay. So I see you all asking questions, but I can only give you general information because I don't know your particular situation, right? I don't know all the details. So everything I can tell you here is general. But if you schedule a strategy session with me or a detailed consultation with me, which you can do by going to my website, lilylegal.com, and clicking on contact us, or go to lilylegal.com/contact us, you'll be able to schedule a strategy session or a detailed consultation, whichever you choose. And that gives you the opportunity to meet with me, tell me about your specific situation, and then we can talk about the best way for you to gain status or navigate whatever it is you're going through, and if I am able to assist you in that process. All right. All right, Zach. Did the new memo of NTA will apply to someone who has this case decision pending since November 2024? Yes, it applies to all cases. As long as there hasn't been a decision yet, it applies to every single case that's currently in front of USCIS, regardless of when it was filed. It's about when they make the decision. Mhm. So for cases that have already been decided, we don't really see them going back like 10 years and putting someone in removal proceedings, but we do see them, like I do predict that they will be doing it more for cases that they deny moving forward. But typically not, but I don't foresee them having the resources and manpower to really go over cases that were denied in the past. You are very welcome, Manny. Honestly, you all are the reason I do this every single week because y'all ask such good questions. Okay, you guys ask so many good questions, and it makes it all worth it. Because sometimes I'm like, oh, what if like there's no questions? And then after we after we get going, you all come on and ask me all the great questions. And I always say I appreciate you all for asking the questions because there's someone out there that's going to watch this video or is watching right now that has the same exact questions that you do and don't feel comfortable asking, right? So by asking your questions, you are helping me educate people and give people the information they actually want. All right. And as always, I always tell you guys this, I'm going to keep saying it. If there is a specific topic that you want me to cover, either on a pre-recorded video or on a live, please send me a DM on either Instagram or Facebook and let me know what that is. And you may just see it as the next topic for either a recorded video or a live session. So please feel free to be specific on what you want me to cover. It really does help me make sure that I am giving you exactly what you need. All right. All right, guys. So I will be seeing you all next week, Friday, with more immigration chat. If you Like I said, if you have questions and you're watching this on a replay, please put it in the comments. I truly do appreciate you all for taking the time. And if you haven't liked this video already, go ahead and like it. And for those that are joining late and don't know who I am Attorney Lillian Chukura. I'm a US-based immigration attorney, and I help my clients get green cards and citizenship for themselves and their families using the US immigration law system, whatever it looks like right now. Okay, whatever that system looks like right now. Zach, I have two options for a consult. So we have the strategy session, which is free, and then we have a more detailed consultation, and that is $75 right now. Okay. And both of those options are up on my website. So if you go on my website and click on contact us, you'll be able to pick the one that you want, either the free option or the paid option. Completely up to you. We do not, we do not fault anyone for picking either or. So feel free to do that. All right. So thank you all so much for joining me, and I will see you next week. Be safe out there.